about the term and conditions of that agreement?
No.
Didn't you ask the Eapons what happens if I'm late?
I asked what happens if I don't arrive in exactly on 12 o'clock. I said, will I be in trouble?
On a cold February night in 1997, an ambulance rushed into a Massachusetts hospital carrying a baby boy who was barely clinging to life. 8-month-old Matthew Eapon had been found unresponsive in his crib. Doctors quickly discovered a fractured skull bleeding behind his eyes and brain swelling that pointed to catastrophic trauma. His injuries, they said, were consistent with violent shaking. Within days, Matthew would die. And within weeks, the young woman who had been caring for him, a 19-year-old British au pair named Louise Woodward, would be accused of murder. What followed became one of the most controversial trials of the 1990s. It was a story of trust and betrayal, science and uncertainty, and of a courtroom that became the stage for a debate about guilt, mercy, and the flaws of justice itself. But what really happened in that quiet Massachusetts home? Did Louise Woodward violently shake a baby to death in a fit of anger? Or was she the victim of a system desperate for answers? Louise Woodward wasn't a hardened criminal. She was a teenager from Elton, a small town in Cheshire, England, bright, ambitious, and restless. She took a gap-year job as an au pair in the United States, one of thousands of young women who crossed the Atlantic to work for American families. To Louise, it was supposed to be an adventure, a chance to see the world before university. The Eapons, a well-off medical family in Newton, Massachusetts, seemed like the perfect match. But in January 1997, things went terribly wrong. Louise had been caring for baby Matthew and his 2-year-old brother. According to prosecutors, on the evening of February 4th, Louise snapped. They argued she had grown frustrated with the baby, shaken him violently, and slammed his head, causing injuries that proved fatal. The medical findings were damning. Doctors testified that Matthew's injuries were not consistent with a simple fall: a fractured skull, subdural hematoma, retinal hemorrhages. Signs, they said, of shaken baby syndrome. The phrase itself carried enormous weight at the time. It suggested deliberate violent force far beyond any accident. Prosecutors wasted no time framing the narrative. Assistant District Attorney Gerald Leone told the jury, "This was not an accident. This was an assault." Louise Woodward took that child's life because she could not handle the stress of caring for him. But Louise told a very different story. She admitted she had been a little rough with Matthew but denied intentionally harming him. She said she may have dropped him on the couch after he struggled while she was dressing him, but insisted she never shook him with the kind of violence described by doctors.
Did you ever shake Matthew Eapon violently?
No.
Did you ever hit Matthew?
No.
Did you ever slam Matthew about the head?
No.
Did you ever slam him at all?
No.
In a police interview that later played in court, Louise confessed, "I may have been a little rough with him, but I never hit him. I never ever hurt him on purpose." The trial began in October 1997 and quickly became a media sensation, not just in America, but across the Atlantic. In Britain, newspapers called it the nanny trial, TV networks broadcast daily updates. The courtroom was packed with reporters. For many, it wasn't just about one young woman's fate. It was about cultural clashes, medical science, and the uneasy relationship between parents and the strangers they trust with their children. In court, the state's case leaned heavily on medical experts. Dr. Eli Neuberger testified that the baby's injuries could only have been caused by violent shaking. The timeline prosecutors argued pointed squarely at Louise. Matthew had been healthy earlier that day. By the time his parents returned home, he was unresponsive. Who else could have inflicted the injuries? Defense attorneys Barry Scheck and Andrew Good pushed back. They argued the medical science was far from certain. Could the injuries have been older, perhaps caused days or weeks earlier?
I just told you that on February 4th of this year, Louise Woodward slammed Matthew Eapon's head down on a hard surface.
Could they have been worsened by a minor fall? Their star medical expert, Dr. Patrick Barnes, challenged the shaken baby diagnosis. He told the court that medical science had evolved, that the old assumption that certain injuries automatically meant shaking was flawed. The defense also painted Louise as young, inexperienced, and out of her depth, but not a murderer. Scheck argued passionately. She is guilty of being young, naive, and sometimes careless, but she is not guilty of murder. Still, the prosecution pressed hard. They showed the jury Louise's police interrogation, where she admitted she had been a little rough. For prosecutors, those words were the crack in the defense's armor, proof that Louise herself had admitted to handling the baby with force. The courtroom atmosphere was tense, emotional, and deeply divided. On one side, the grieving Eapen family devastated by the loss of their baby boy. On the other, a young woman fighting for her life, her parents watching helplessly from the gallery. When Louise herself took the stand, the jury watched her closely. At times she seemed composed, at others shaken. She told the court, "I would never hurt Matthew, I loved him. He was like a little brother to me." But under cross-examination she struggled with details, sometimes contradicting herself. After weeks of testimony, the case went to the jury. On October 30th, 1997, they delivered their verdict, guilty of second-degree murder. The courtroom gasped. Louise broke down sobbing as the reality sank in. At just 19 years old, she faced the prospect of spending the rest of her life in an American prison. The judge, Hiller Zobel, later described that moment. "The jury has spoken. They found her guilty. It is not for me to say they were wrong, but the case didn't end there." In a rare and controversial move, Judge Zobel used his authority to reduce the conviction. He ruled that while the jury's verdict was valid, the evidence better supported involuntary manslaughter. He sentenced Louise to time served just 279 days and ordered her immediate release. In his ruling, Zobel wrote words that still echo decades later. "I am morally certain that allowing this defendant to go free today will not endanger the community." This was not murder. It was a combination of inexperience, frustration, immaturity, and some anger, but not malice. The decision shocked the nation. To the Eapens, it felt like justice denied. To Louise's supporters, it was a moment of mercy and common sense. The press exploded. Headlines screamed, "Free nanny justice for Matthew Britton," and America debated endlessly. Louise returned to the UK, where she was greeted with sympathy and scrutiny. In equal measure, she tried to rebuild her life, studied law, and mostly withdrew from the spotlight. But the questions never truly went away. Did she get away with murder? Or was she a victim of flawed science and a legal system caught in a storm? In later interviews, Louise reflected, "I was just a kid. I didn't know how to defend myself. I never hurt that baby, the way they said. But once you're accused, it's like nothing you say matters." The case also left a legacy far beyond one young woman's fate. The trial forced doctors and courts to re-examine shaken baby syndrome, sparking years of debate among medical experts. Was the science truly settled? Could some babies have died from less obvious causes, misdiagnosed as abuse? Even today, the Louise Woodward case remains a touchstone. It's taught in law schools, discussed in medical journals, and remembered by those who watch the drama unfold in real time. It asks us to wrestle with haunting questions. How do we know when a tragedy is a crime? How certain must we be before condemning a young life to prison? And when science changes, what does that mean for justice? Louise herself once summed it up in a single sentence that still divides opinion. "I was guilty of being young and careless, but not of murder." In the end, the case of Louise Woodward, the so-called killer babysitter, is less about easy answers than it is about uncomfortable truths. A baby lost his life. A young woman nearly lost hers. And somewhere in between lies a story that still fractures families, divides experts, and lingers in the shadows of the justice system. Because in cases like these, the line between guilt and innocence, between accident and crime, is never as clear as we want it to be. And sometimes even a verdict doesn't close the case, it only opens more questions.